Good afternoon, Advocate Bezuidenhout.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm well under the circumstances, but yes, I'm very happy to be here.
Have you been waiting for this moment for quite some time today?
Well, I've been sitting across the passage from about, I think, 10:15 this morning, but yes, it's always
Yes.
worth the wait. I don't mind waiting.
No, I wish to apologize to you on behalf of all of us because we took much longer with the previous candidate. So the time when you expected to be interviewed came while we were busy. And other candidates are also going to end up coming in later than they had planned. But we apologize.
It's not a problem, Chief Justice.
Yes. I also thank you for availing yourself for consideration for appointment as a judge of the KZN division of the High Court. We appreciate the fact that you have made yourself available. I'm going to ask you certain questions, and when I'm done, I'll ask the AJP to ask you such questions as he might wish to ask you, and thereafter I will give the opportunity to the MEC who is here representing the Premier, MEC Mshengu, and thereafter other commissioners might have questions. But I do want to say that you will get very crisp questions from the commissioners. There will be no preambles. You'll just get crisp questions. So I would urge you to also give crisp answers.
Chief Justice, I think that time of the day and the week might maybe encourage everyone to be crisp.
And also, don't expect any other commissioner to greet you now, even if they know you have greeted. I've greeted you on behalf of all of them. Okay.
Thank you, Chief Justice.
All right. I see that in terms of academic qualifications, you hold a BUris degree and an LLB degree. Is that correct?
That's correct.
And you got these qualifications from University of Pretoria and University of South Africa.
Yes, that's correct.
Yes. The BUris was in 1991 and the LLB was in 1999.
That's correct, Chief Justice.
And you started your working life in the early 90s as an admin officer in the Department of Trade and Industry. Is that right?
That's correct.
And later on, you were appointed as a public prosecutor, and you worked as a public prosecutor from 1993 September to January 1999.
That's correct.
And in July 1999, you were admitted as an advocate and you joined the Society of Advocates of KwaZulu-Natal.
Yeah, I think I was admitted in either April or May of 99, but I started practice on the 1st of July at the Pietermaritzburg Bar.
Okay. And have you been practicing as an advocate since then up to now?
Yes, yes.
Yes, and that gives you how many years of practice?
Chief
About
Justice,
21?
It will be the 1st of July, coming 1st of July, it will be, I think, 23 years.
23 years.
Yeah, if my maths are correct.
Yes.
It's late in the day.
Yes. And when did you take silk?
I applied in April 2020 and my latest patent was signed on the 5th of May last year, 2021.
Oh, you only applied after you had done more than 20 years in practice, huh?
Yes, I applied for the first time in 2018. There were quite a few people at our bar that applied at the same time, a few of my contemporaries that started practice together with me. And because of the well, it's quite a small bar, and at the end they decided to only award silk to 4 of the 8 or 9 applicants, and I wasn't one of those 4. And then I applied for the second time in 2020, and then I was awarded silk after that.
Yes. And tell me your practice, the cases that you have been doing over the years, to what branches of law do they relate?
Chief Justice, I've heard people describe it as a generalist practice. I've done a lot of family law. Obviously, when I started practicing, being a woman, you get briefed to do divorces and custody and those types of disputes, delictual matters, motor vehicle collisions. I've done a few fire cases. I enjoy doing fire cases. I've done commercial work. I've done work for banks. Basically everything that comes across my table that I get briefed to do. So I haven't specialized in anything specific, but I've done a wide variety of matters.
Have you done, have you had a lot of commercial law cases, commercial work?
Chief Justice, I wouldn't say it's a lot. I would probably estimate it's maybe 20 to 30% of my practice.
Yes.
It's difficult to put a figure. If you try and think back over the years what's been done, it's difficult to put a figure to it, but I've done, yes.
Yes, labor law work?
Labor law, not so much. In the beginning of my practice, I appeared in the CCMA and the Labor Court a few times, but that's not something that I pursued.
Yes.
I didn't enjoy it that much. I just
Administrative
got
law?
briefed in other matters.
Administrative law?
Not a lot. Not a lot.
Constitutional law?
I've not appeared in the Constitutional Court. Constitutional law matters, obviously in a lot of the cases I deal with constitutional issues, but it's nothing to do with having certain sections declared unconstitutional. That type of briefs didn't come across my desk. But if you appear for someone a parent who's maybe trying to take his child away from an abusive parent, the Constitution comes into play. So in that regard, it's not that the Constitution is unfamiliar with me or constitutional issues, but yes, I haven't appeared in the Constitutional Court.
And competition law?
Competition law, no. There's not much in Pietermaritzburg. It's a small bar, and I don't know if there's many practitioners, even in Pietermaritzburg or in Durban for that matter, that would have had much exposure to competition law. Seems to hang around the Gauteng area, Cape Town.
Or maybe there is no competition in KZN.
Maybe not. I don't know if that's a good or a bad thing.
Okay.
We all get along well there. We don't compete too much with each other.
And have you done a lot of delictual matters?
Oh, yes. No, definitely.
Yes.
Definitely.
Now, how long have you acted in the High Court?
Chief Justice, if my calculations are correct,
Roughly, even if it's not accurate, precise, but roughly.
No, I've calculated it as 50 weeks. I think that's just under a year.
Yes.
I started, my first acting stint was November, December 2019, and then since then I've acted intermittently over the time. My last acting stint was now this last session before the recess.
Yes.
But I've done quite a few acting stints.
Yes. And during the time in practice, are there some cases that you have done that have ended up producing reported judgments?
Chief Justice,
where you appeared as counsel, not which you...
Yes, I understand that. Obviously, I don't have control over who reports the cases, but there's one matter that was reported, I mentioned it in my form. I think it's either the Sibia matter or the Nyoko matter. If I can just have a look.
So there would be one or two, you say?
I think there's in the SA law reports there's one, and then there's one or two others just in judgment online.
Yeah. And in terms of judgments you have written as an acting judge, are there some judgments that have found their way into the law reports?
Only two at this stage, but
Yes.
hopefully more will come.
Yes. Okay. And how did you find acting when you started acting for the first time?
Chief Justice, I must say the first day I had to appear in motion court, or not appear, had to go and sit in motion court, I was quite nervous because you walk in there and you suddenly look onto practitioners that just a week before you were sitting next to them down there in motion court, and you know you're going to be judged by them. But as soon as it started, I just felt absolutely at home, and I actually now enjoy motion court quite a bit because it's a bit of an adrenaline rush on the one side, but it's also a way of interacting with counsel, and I've enjoyed motion court and acting overall. The first time I had to sit down and write the judgment, and I'd finished doing my research and knew I could now sit and start writing. It was an incredible feeling. That's where the magic happens. You start writing a judgment and everything comes into place, and you just know that this is what I want to do. And that for me was the job satisfaction factor was sky high. That's why I'm here today, because I'm enjoying doing that.
Yes. In terms of your practice, do you still do civil trials and criminal trials?
Chief Justice, because I've been acting intermittently over the last 2-3 years, I must say my practice has taken a little bit of a backseat because I've decided to focus my energies on acting and getting experience as an acting judge. I finished last year, I had a part heard as counsel that I finished during the recess periods and in the periods when I was not acting. That was my last trial that I did. It was a divorce matter that ran over about 2 or 3 sessions because it was quite a long, drawn-out matter. But I basically, at this stage, when I go back to chambers, I get briefed to do a few things here and there, but a lot of the attorneys know that I'm not available for long-term projects. So if there's something like a quick urgent application or going to court to oppose an urgent application, something to that, that's what I do at the moment. The long-term things like getting briefed for trials that's coming up is taking a bit of a backseat at the moment.
But previously you did civil trials and criminal trials.
Oh yes, no,
as
I
counsel.
was in civil trial court continuously. I did a lot of civil trials. That was fighting in the trenches. That was my practice. It was about. I was in trial court very often.
Yeah. And you have sat in full bench appeals as an acting judge?
Yes, yes.
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 And done criminal trials as an acting judge as well?
I've spent about, I think, 13 weeks in criminal trials. I've completed 2 long criminal trials, and at the moment, well, we sat last week in the one I'm currently busy with. We finished all the evidence last week. It's been adjourned now for argument and for sentence. But I was 13 weeks in criminal trials. I've done a civil trial. I've been allocated from my notes 13 civil trials. Obviously, a lot of them got settled along the way, and we didn't end up in court, but one of them was a fire case that ran for a week. We were supposed to carry on with that case during the recess last week, but the parties settled, so we didn't carry on with that. But yes, I've been in full bench special opposed motions, full bench criminal appeals and civil appeals.
Yes. And what is your understanding of the rule of law?
Well, Chief Justice, it's such a general term, and it's in the news so often, but it's basically everyone is subjected to the laws of the country, whether you're a state organ or an ordinary man on the street or a government official, we're all subject to the same laws of the country. And that underpins our democracy.
What is your understanding of the doctrine of separation of powers?
Well, we as judges try to not interfere in other spheres of spheres of government, either the legislature or the executive. But sometimes we don't have a choice. But yes, those powers are everyone is supposed to stay in their lanes: the judiciary, the executive, and the legislature.
Do you know whether the model of the separation of powers that we have in South Africa is the same as in other countries, or it's got its own features in South Africa? Is that something you would know or not?
Chief Justice, I have to think back very, very far to my university days to try and compare the situations in other countries. I would think ours is probably based on other countries as well, but we might be unique. I mean, there's a lot of things in South Africa that's unique. Our constitution is unique, and I wouldn't be surprised if that is also unique. But
And what can you tell us about the independence of the judiciary?
that is the most important thing of what we do. We have to be independent. We cannot pay attention to all the noise out there. We cannot let ourselves be intimidated by what people say in the press and newspapers. We cannot be swayed by or influenced by criticism out there. We've absolutely got to just put the blinkers on and focus on doing what we have to do and be independent in doing so. It's probably the most important thing of being a judge.
What can you tell the commissioners to show that you are somebody who embraces the values of the Constitution?
Chief Justice, I feel very strongly about the Constitution and about the rights of people. That's partly why I want to do this job, because someone in our position can make a difference every single day. Someone can come into court, maybe an unrepresented litigant can come into court who absolutely begs for an opportunity to make arrangements to not lose his house. There we can make a difference as a judge. A litigant can come into court, a woman whose husband is divorcing her and she lost her job, she cannot afford legal representation, and she just begs for an opportunity to approach a legal aid office. There we can make a contribution. But it's difficult to put it into words. It's just something I feel passionate about, and it's what judges have to do, is to pay attention and do their jobs with the Constitution in the back of their mind every single day they walk into court.
Yes. I'm now going to give the opportunity to the acting judge president to put questions to you. He and the MEC and the commissioners will put questions to you aimed at satisfying themselves how your appointment, if you were to be appointed, would meet the selection criteria that this commission has approved as the criteria that it uses in interviews. And those criteria include establishing whether you are duly qualified, whether you are competent technically, and whether you have capacity to show energy and motivation, and to show whether you would promote the values of the Constitution, and also to show, to ask the question whether what message your appointment would send out to the community at large if you were to be appointed. And the Constitution does require that when this body considers the filling of judicial positions, it should consider the demographics. So they will ask you questions that are aimed at satisfying themselves about that. So I will now give the opportunity to the acting judge president. I just point out AJP because you were not here when I pointed this out in the morning, that due to time constraints, the commissioners have restricted themselves to 2 questions, and I'm probably going to restrict them to even 1 this afternoon. And, but I do give the head of court more leeway to ask more questions because the head of court knows the needs of the division. So I'll give you a little bit more leeway. You may start.
Thank you, Chief Justice. Good afternoon, Ms. Bezuidenhout.
Good afternoon, Acting Judge President.
How are you feeling today?
I'm feeling good, as can expect it. It's long in the day, late in the day.
Okay. During your acting stints, did you encounter any problem? If the answer yes, what problem it was and how did you resolve it?
Acting Judge President, I didn't really encounter any problems in doing the work. The only problems I encountered were technical problems such as maybe recording machines in court not working and having to reconstruct proceedings, but other than that, I haven't encountered any problems.
Okay. So is there any area of law where you feel that you still need an exposure?
Acting Judge President, it's difficult to answer that because over the last 3, almost 4 years, I've been given a wide variety of cases, and some of them were completely out of my wheelhouse, but I went and read the cases and looked at the statutes and managed to deal with those matters. And I feel confident that anything that gets placed before me that is maybe something that I haven't previously dealt with, I can deal with it. I wrote a judgment that dealt with business rescue proceedings in terms of the Companies Act, and I'd, in my practice, never been involved in a business rescue matter. But I read the case law and I did the research and I was able to deal with it. So I'm confident that I can handle anything that comes my way. And if I myself can't handle it, then there's lots of other judges that I can discuss the problem with and get advice, because I do that quite often. You've got lots of legal minds there that needs to be tapped when you need someone to bounce ideas off and get some advice from.
Okay. Did you receive any?
May I ask you, AJP, to raise your voice to speak up?
Sorry. Did you receive any aspirant judges training?
Yes, I attended. Unfortunately, it was an online course in January because of the whole COVID situation, but I attended the aspirant judges course in January this year. It was pretty amazing. I'm just regretting that I couldn't attend the full course and attend in person so one could meet everyone and exchange ideas, but it was very, very educational. And the part that I enjoyed most was there was a lecture about judgments, because I thought, although I enjoy writing judgments, sometimes you have that writer's block where you just can't get that first paragraph down. And when I heard some of the judges, like I think it was Justice Matopo, explaining how he sometimes battled to start, I felt immediately at peace, because I then realized I'm not the only one and that it's a common problem, and that was quite enlightening, but it was very helpful.
So are you now satisfied that we are ready for permanent appointment?
Well, that's why I'm here. I feel that I'm ready, but I might be the only one.
Is there any specific skill that you'll bring with you to the bench?
Acting Judge President, I wouldn't say there's a specific skill. I think I've got a combination of skills that taken together would make me a good judge. I've got a lot of experience in litigation. I was a prosecutor for almost 5.5, 6 years. I've been in practice for almost 23 years. I've got the courage to go into court, and I've got the courage to tackle matters. And yes, I'm a hard worker. I've been phoned at 4 o'clock on a Friday afternoon and asked whether I could do an urgent application, hear it on Tuesday. They brought the papers to me on the Saturday morning, almost 1,000 pages, and I dealt with the matter. Those are the skills that I bring to the table. I've got the experience and I can work hard, and I've shown that I can produce what needs to be produced as a judge.
Okay. Lastly, if you are appointed, is it correct that you will be the first white female judge to be appointed in the Pietermaritzburg High Court?
Yes, as incredible as that sounds, because at the moment there's, of the 13 judges in Pietermaritzburg, there is only 2 females, 2 black females. I'll be the first white female judge, and from our bar, the Pietermaritzburg bar, I'll be the first woman that's appointed to act in the High Court in Pietermaritzburg, so it will be historic, and it will be incredible. And the other ladies at the Pietermaritzburg bar is just 100% behind me and support me, and all wish to see this moment where someone from there, one of their own, can actually be a judge in Pietermaritzburg.
Okay. Thank you, Chief Justice.
Thank you, AJP. MEC?
Thank you so much, CJ. The first question, what is your understanding of the notion of transformation of the judiciary? And in the context of KwaZulu-Natal, what is it that people of KwaZulu-Natal should see such that they can conclude that indeed transformation of judiciary is happening to their benefit?
Thank you, MEC. I think if the ordinary man in the street looks at the bench in KwaZulu-Natal, if I look at the figures, there's 5 black men, 5 black females. I think there's 3 Indian males, there's 4 Indian females, 2 colored males, 1 colored female, 5 white men, 1 white female. It depends on obviously which member of the population, but it's got the appearance of quite a already transformed bench.
Am I correct to then say your understanding is confined to the changes in the demographics of the bench?
Well, the demographics, I think, are sorted out. If you want to hear me on whether the attitude of the judges on the bench, whether they have transformed and whether they are transformative judges, then I can say unequivocally yes. I have not come across a single judge that doesn't strive for transformation and doesn't hold those values dear to their hearts. That is the truth for every single judge that I've worked with, and I've worked with most of them.
What about access to justice?
That is always tricky because we all know it's a problem, because the ordinary man in the street cannot afford high court litigation. The ordinary man in the street, to get themselves to be represented in the High Court, would either have a very deep pocket, or they would have to qualify for legal aid. And there's quite a gap, because you've got, if you want to apply for legal aid, there's like a ceiling. So, for instance, I'm not sure what it is. I'm a bit out of touch with that. But say, for instance, the ceiling is earnings of 5,000 Rand a month. So someone who earns 5,000 Rand or less would qualify for legal aid. But the person who earns say 15,000 rand a month would not qualify for legal aid, but that person would still not be able to afford to pay for counsel to represent them in the High Court. And it's that middle group of people who do not have access to that type of justice. And I'm not even beginning to talk about the people in rural areas. I know our own acting judge president has written books about the systems out in the rural areas, the tribal courts and the tribal councils. There's lots of work still to be done to ensure that people out in the rural communities get access to justice. And it's a problem because it's a money issue, because there must be money available to ensure those people get access to justice.
Well, I see that we have not really featured or contributed in publications.
I assume that will be your last question, MEC?
Yes, indeed.
Okay, all right.
CJ. Why is it so? Is it because of time, or you have found no value in making contributions to publications?
It's a time, and I've never thought that I've got the talent really to write things. I would concentrate my efforts on the people that I work with, people at the bar, and yes, that's where my contributions are, not in putting pen on paper, unless it's in a judgment.
Thank you, MEC. Commissioners, Commissioner Moimang.
Thank you, Chief Justice. Advocate Bezuidenhout, just make me understand how did you get around the argument raised around the legality principle and the rationality as components of the rule of law as it was raised in the TAIL South Africa against the National Director of Prosecution.
Yeah, Commissioner, in that matter, it was actually a very simple question that had to be decided, and that was simply whether there was reasonable and probable cause for the NDPP to sign that certificate. We obviously had to investigate and look from the papers whether they contravened the principles of legality, but bearing in mind the amount of information that was placed before the NDPPs, well, the first one and the second one, it was actually quite, I don't want to say easy, but it was, yeah, well, it was easy to determine that they had sufficient information before them to make that decision. It was not our job to decide whether there was a prima facie case or whether someone was guilty or not guilty. We simply had to look at what was the information that was before that person before he made the decision to sign that certificate. And we concluded that there was sufficient information, and that's on the basis that I made the finding that I did, that was supported by the other two judges.
Thank you, Advocate. Thank you, Chief Justice. Very crisp.
Thank you, Commissioner Moimang. I commend you for one question. Commissioner Singh.
Thank you, Chief Justice. I'm going to follow Commissioner Moimang. Good afternoon,
Excellent.
Advocate Bezuidenhout.
Good afternoon, Commissioner.
Just one question. How familiar are you with the existence of traditional courts in KwaZulu-Natal, and what do you think about their role and efficacy?
Commissioner Singh, I haven't been to one. I know there's lots of traditional councils. Traditional courts have got their role to play because they can hear certain criminal and civil matters. The problem there, and maybe it's just for me a problem, is that obviously to keep the process simple and uncomplicated, they don't allow legal representation. I think someone who go and appear in front of a traditional court can maybe take a family member or someone else to represent them, but they're not allowed legal representation, which sort of offends against my feeling of everyone is entitled to have some type of representation when they appear in a court situation. But like I say, if they're there to deal with very simple and straightforward disputes, and they could play a role, because that could relieve some of the burdens that's on the district courts and the regional courts in our areas. But yes, I haven't been there, but it's certainly something that needs to be looked at, and maybe more resources put in to make those traditional courts function in a better way, to relieve some of the burden on the magistrates court.
Thank you very much, Chief Justice. Thank you, Advocate.
I commend you, Commissioner. Let me go to the commissioners who are attending virtually. Commissioners attending virtually, is there anyone who has a question that they feel is important and they want to put to the candidate?
I have no questions. Thank you, Chief Justice.
CJ.
Thank you,
CJ.
Commissioner Breitenbach. Yes, Commissioner
CJ.
Shabangu Mdawe.
Thanks, CJ. CJ, I want to follow up in the question that was asked by the MEC with regard to a transformation, and which issue was also raised by the advocate for transformation, where they indicated that they don't know any involvement of advocate in any transformation.
You may follow up, but that will count as your question, okay?
Yes,
Follow
it's
up.
my question. Yes. So
All
I
right.
want to know, advocate, how many young Black advocates have you empowered when you were still practicing, and you are still practicing?
Thank you, Commissioner. I must confess, when I read that comment in the OFT report, I felt almost saddened, because I've been involved in the lecturing and mentoring of pupils for the last few years. I've been on the pupillage committee since 2016, and I've played a very active role in the bar over many years, and it's a passion of mine to lecture pupils, to teach them, to keep on mentoring them after they've gone through pupillage and they started practice. One of the young Black advocates last year, when he had to start commencing his practice in, I think, January or February of the year, he didn't have chambers, because not in our building or in one of the other buildings was there any office space available for him. And I made my office available. He practiced in my chambers for almost 2 months while I was acting on the bench. I've had young advocates, they become almost my children. I've lectured them in civil trials for the last 3-4 years. Once I finished lecturing them, because we spent quite a bit of time together, I normally would lecture them on a Monday. I would see them through the week. We would have some time together, 3-4 hours before the exams, before the mock exams, the real trial exams. And they become very close to me. And they phone me at odd hours of the day or night asking for advice. People that I lectured 2-3 years ago still phone me for advice. Even now that I've been acting, if they come to see another judge and they see I'm there, they quickly come and they sit and they come and greet me and ask me how things are going, and quickly, while they're there, work in some quick advice to try and get a tip for a brief they're struggling with. So it's to me, yeah, I'm saddened by that remark that they were not sure what I've done for transformation, because I've been actively involved in the bar with the young generation of people that come into the bar. Black advocates, males, females, yeah, all the junior members of the bar. I'm passionate about advocacy training, and I'm constantly busy trying to teach people. Even in one of my first or second criminal trials, there were a lot of young practitioners who were appearing on legal aid, and I assisted them when they were cross-examining the witnesses. I cannot pass up a teachable moment, and I'm constantly involved with the junior bar and the junior members. So yes, that's.
Okay.
I've been very involved in transformation.
Thank you.
Thank you, Advocate.
Thank you.
CJ.
Thank you, Commissioner. Try for crisp answers, Advocate Bezuidenhout.
Sorry, Chief Justice, I'm going to try my best.
There is nobody among the commissioners, there's nobody else among the commissioners attending virtually who wishes to say something.
I would like to pose a short question, Chief Justice.
You have a short question.
Yes.
Okay, all right.
Okay. Thank you, Advocate Bezuidenhout. You don't have to refer to it, but in the bundle, there's the Lessier versus Stainton case, and in paragraph 141, you may just make the point that caveat subscriptor, beware he who signs, or let the signer beware, is still part of our law. And then you refer to, in a footnote, to the very old authority, and it is a classical authority, George versus Fairmead, which approves of a 1903 case. Did it not occur to you in doing the judgment perhaps to refer, there's been such a lot of development around caveat subscriptor and discussion of it in more recent case law, etc. So did you consider that, and did you consider the constitutional impact or the constitutional effect on the beware he who signs rule?
Thank you, Mr. Commissioner. I must say that was not even remotely the main focus of the judgment and the issues I had to deal with. That was just a very small thing that I added in, and yeah, I could have expanded on that, but I didn't think it was necessary, and I just quoted the most classic case, and yes, you're right, I could have expanded on that, but I didn't. But that case, I might just mention, after completing my form and submitting my application, a few days later, it came to my knowledge that the defendant in that matter, although I refused leave to appeal, he then applied for special leave to the Supreme Court of Appeal, and that was refused. And the defendant again asked for a reconsideration, and that, I heard last week, was also refused by the SCA.
Thank you. And I don't have a problem with the finding of the judgment, but my question really relates to the fact that when one quotes authority and so on, that one also has regard to a bit more updated authority.
Understand that. I'll take your point.
Yeah, okay.
Thank you, Chief Justice.
Thank you, Commissioner Barnard. Commissioner Pillay. As things stand, it looks like she will be the last one. Oh, there will be Commissioner Schlemmer. Okay. Commissioner Pillay for now.
Thank you, Chief Justice. Good afternoon, Ms. Bezuidenhout.
Good afternoon.
May I refer you to your judgment of State versus Como? It's at paginated page 92 of the bundle. Now, this was a case, it was a criminal matter involving an accused who, on multiple occasions, stabbed a woman multiple times until she died. You recall the case?
Yes, he pleaded guilty in front of me.
Yes.
Yes.
So,
Yeah, sorry, I don't think I've got the right, sorry, page.
it's paginated page 90, if you can go to 96 for now, just to shorten the question.
Yeah, my numbers are a bit different, but
That's
I'll
fine.
find the
If you
decision.
can go to paragraph 39.
Okay, that's going to help me. I'm with you.
All right, so in paragraph 39, you recognize that violence against women is being perpetrated on a daily basis, etc., and that it's a cause for concern. But then you do two things which I really want to question you about. The first is in paragraph 40, you say it is unclear if the accused attacked and murdered the deceased purely because she is a woman. And that's the first thing I find of concern. I'm not sure what kind of evidence you were looking for to suggest that he attacked her because she was a woman. And secondly, on the next page, at paragraph 50, sub C, when you're considering additional factors, you say, I've also taken into account the following additional factors. the fact that the accused and the deceased were not involved in a relationship, and there was accordingly no emotional bond between them that could possibly explain the accused's violent reactions towards the deceased. So you seem to imply that if there was an emotional bond between them through a relationship, etc., that would account for and explain the violence against her.
Well, thank you. That is more to look at, because he wasn't forthcoming to explain what it is that set him off to be so incredibly violent towards this woman. If he had come and said she was his girlfriend, for instance, and he found out that she had been unfaithful, then that strong reaction would maybe go to explain why there would be such a vicious reaction from him. It's in no way meant to suggest that I would have accepted that as some type of excuse. I'm trying to find a reason for why it was a vicious attack. If you look at the medical records, it was just incredible. And I was trying to find some reason as to why he responded in that way, especially in light of the fact that nothing was forthcoming from the accused himself. If you understand what I'm trying to say. If it's a jealous rage because there was a relationship between them, there would maybe be some understanding, not an excuse, some understanding.
I'm sorry to say I don't understand, but I'll stick to the one question rule. Thank you. Thank you, Chief Justice.
Sorry, I couldn't answer your question. Sorry.
Well, I can assure you, Commissioner Pillay, that I do appreciate that when you put questions or anybody puts questions in relation to a judgment, one question might make it difficult. So I'm alive to it. But so I think in the past I would allow a little bit, because sometimes it's difficult to just put one question in relation to a judgment. But I encourage you and everybody to do the best you can. Okay,
I'm
thank
nothing
you.
if not compliant, Chief Justice, so I will comply. Thanks.
Commissioner Schlemmer?
Thank you, Chief Justice. Good afternoon, ma'am. I would just like to know, you said in response to a question by one of the commissioners that you don't let any opportunity to teach pass, and that is why when some of the junior counsel in court cross-examines, then you assist them. Now, my question is, do you assist them whilst you are on the bench, or do you assist them while you are just generally also counsel in court? Because I just want to be certain, to what extent do you teach whilst you are on the bench, or am I misunderstanding?
I certainly do not teach while I'm on the bench. After the completion of the case and when the matter was finished, they all came to greet me in chambers. And I couldn't resist the opportunity to hand to them a very good article written in, I think it's our Advocate magazine, that was written by one of the judges in our division on cross-examination. So I handed it to them because there were 2 or 3 of them that were very young, but I could see had quite a lot of potential, and they just needed the right article to read to push them in the right direction and help them for future. But I certainly would not interfere in court unless one of them would perhaps be on the verge of opening a can of worms when they were putting something to a witness that would be to the detriment of their client. But yes, I'm definitely not teaching when I'm on the bench.
Thank you. That allays my fear.
Thank you.
Thank you, Commissioner Schlemmer. I think we have come to the end of this interview. Thank you very much, Advocate Bezuidenhout, for making yourself available. In case there are 2 or 3 points that you would like to emphasize to the commissioners as points that you would like them to specially bear in mind as they consider your candidature, I give you 3 minutes to address those points. But if you feel that all issues have been adequately addressed, that will be fine as well.
Chief Justice, I'm going to not make use of that time because I know I've got quite a few colleagues waiting in the wings that's anxious to get their interviews on the go, so I'm not going to take that time. I'm simply going to say that my belief is that I'm ready and that I've got enough experience and that I will be able to do this job. And that's all I'm going to say, because I know there's still lots to come after me. Thank you so much, and thank you for the opportunity.
Thank you very much, and you are now excused.
Thank you, Chief Justice.
Thank you.